In this presentation, I'm going to talk about potential competition as this concept has been developed in recent case law of the European Court of Justice, specifically with reference to the rules governing anti-competitive unilateral and coordinated conduct, so Article 101 and 102. Some very general introductory points about potential competition. It's long recognised that EU competition law protects both actual and potential competition. And by potential competition, we mean the extent to which the activities of or the impact of conduct upon an undertaking which is not already present in a market should be taken into account when assessing the behaviour of undertakings that are present in that market. So having identified a relevant market and figured out who's currently active in the market, to what extent should we take into account the presence of players outside the market when applying Articles 101 or 102. Why do we take into account potential competition? Well, of course, competition is a dynamic process, and in particular, potential competition is seen as the precursor to enhanced actual competition. So if it's permissible to halt or delay future entrants' participation for market entry, then that potential competition can never crystallize, can never come into existence as actual competition. Potential competition is a key theme in a couple of recent cases of the European Court of Justice, which really develop this idea as a legally relevant construct within EU law. The cases are generics from January 2020 and Lundbeck from March 2021. The cases really need to be seen together. They were really adjudicated by the Court of Justice together, and both feature very thoughtful opinions written by the same Advocate General, Advocate General Cocotte. Both cases concern pay-to-delay agreements, so reverse payment settlements that include transfer of values by originator drug companies to prospective generic entrants as proprietary medicines are coming off patent, on the condition of those prospective entrants either delaying or abandoning entry. And the question in both cases was whether these agreements could be construed as anti-competitive agreements contrary to Article 101 and indeed in generics Article 102, given that the undertakings concerned had never competed within the same relevant market. So the generic manufacturer had not yet operated in the proprietary market. Could they nonetheless be construed as at least a potential competitor of the originator company? The court, particularly in generics, really sets out some very basic points about the concept of potential competition in EU law. So they confirmed that when you're applying Article 101 to claimed horizontal cooperation agreements, this requires that the coordination at issue involves undertakings who are in competition with each other, if not in reality, then at least potentially. What do we mean by potentially in competition with each other? Well, the potential competitor must have real and concrete possibilities to enter that market and compete with the undertakings established in that market. So by definition, the potential competitor is not yet present in the market, but they must have real and concrete possibilities for doing so in future. What do we mean by real and concrete possibilities? Well, quite helpfully, the court distinguishes this standard from two standards at either ends of the kind of spectrum of possibilities. So real and concrete possibilities for entry are more than a purely hypothetical possibility of entry or even the mere wish or desire of the manufacturer to enter the market. So pure speculation about future entry is not sufficient. But on the other hand, there is no requirement that it must be demonstrated with certainty that that manufacturer will in fact enter the market concerned and succeed in competing there in future. So it's not the same standard as a test for actual competition. You don't need absolute certainty as to what's going to happen in the market. Ultimately, the real and concrete possibilities test is one that requires a case-by-case determination. It's very much linked to the facts of a particular case. However, in generics and Lundbeck, the court discusses a number of potential indicators of whether potential competition exists. I'm going to look at these under 5 subheadings. The first, and according to the Advocate General, the essential factor on which categorization as a potential competitor is based is whether that potential competitor has a, quote, inherent ability, and this is the phrase introduced in generics, to enter the market. An ability to actually come into the marketplace and compete. This is determined by two factors, a more objective abstract factor and a factor which is more personal, you might say, to the potential entrant. So first, it needs to be demonstrated that it is possible in principle for any suitably situated undertaking to actually enter this market. And this is determined by the existence of barriers to entry, and in particular, the question whether the barriers to entry into that market are insurmountable. This is a high threshold, so it has to make entry impossible rather than merely more difficult or uncertain. So for example, in both generics and Lundbeck, the generic competitor was going to have to fight patent litigation suits before they could lawfully enter the market. It wasn't entirely clear that they would win those lawsuits, but the fact that it was uncertain that in the longer term they would legally, lawfully be able to enter was not considered to be an insurmountable barrier to entry, particularly because this was commonplace in these pharma markets. Similarly, in Toshiba, which involved a worldwide market sharing cartel between producers located in Europe and Asia. The Asian producers had no customer base in Europe. They had no established sales channels, but that again was not held to be an insurmountable barrier to entry into the European markets should the producers wish to do so. On the other hand, in Eon GDF, also a market sharing case, the defendants were the incumbent natural gas companies in France and Germany. They agreed not to compete in each other's home markets. But even if they hadn't done so, it was impossible for them to enter their respective home markets because these were protected by legal monopolies. And so even without the market sharing agreement, there was no possibility of potential competition. And so the agreement could not be held to be a restriction of competition because no possibility for competition existed at the time. We also need to think about what preparatory steps the specific potential entrant has already taken to date. And in her opinion in Lundbeck, Advocate General Cocotte grouped these into administrative, judicial, and commercial steps. So administrative steps would be any regulatory hurdles that need to be surmounted before entry is possible. For example, in generics in Lundbeck, it was getting market authorization for selling the generic medicines in the national markets. Judicial steps, perhaps a little bit specific to the context of pay to delay agreements, would be any lawsuits you need to get out of the way in order to be able to enter. And commercial terms would encompass a very broad range of steps from finding premises, employing staff, building up stock, developing distribution chains, devising an advertising campaign, anything you need to do to be practically able to bring your goods to market when you try to break into the new market. The second consideration is whether the potential entrant has evidenced a firm intention to enter the new market. And this is really about distinguishing genuine interest from a mere hypothesis of entry. Again, it's going to be evidenced principally by any preparatory steps towards entry that have been taken by the potential entrant. Intention to enter is not essential. We know this from Toshiba, where the Asian producers had no intention at all of trying to break into European markets. They were happy to stick with the cartel agreement, but they were still held to be potential competitors. But evidence of plans to enter a market in a significant way is considered to be a key indicator of potential competition under, for example, the European Commission's horizontal merger guidelines. And the combination of firm intention and inherent ability as the baseline test for whether potential competition exists suggests that potential competition as a legally relevant concept revolves around discernible competitive constraints. So potential competition is something that is exerted by defined undertakings, the court tells us in Lundbeck. A third consideration is the perception of whether a competitive relationship exists held by the current players in the market. So do the existing players within the relevant market perceive any risk posed by the potential entrant to their commercial interests? This is an interesting factor. Typically assessment under 101 and 102 are rigorously objective. And of course, this is quite a subjective criterion, the perception of competition. But it's relevant to the extent that this perception of competition or otherwise can have a quite significant impact on the behavior of the incumbent players in the relevant market. It may cause them to act in a defensive manner. It may cause them to engage in strategic behavior to avoid competition in future, which can harm consumer welfare. It is considered to be only a confirmatory, not a standalone decisive factor, the court tells us in Lundbeck. And interestingly, in the Toshiba generics and Lundbeck case, the strongest available evidence of the perception of competition that existed was the very existence of the anti-competitive agreement at hand. This might be considered to risk some degree of circularity. The mere fact of concluding the agreement confirms the presence of potential competition, which then in turn justifies classification of that agreement as anti-competitive in nature. But I think it certainly aligns with pragmatic common sense. The fourth factor to think about is the time frame for entry. So the anticipated time frame must be within such a period as would impose competitive pressure. The Advocate General in generics tells us that entry must occur with sufficient speed to form a constraint on market participants. However, it doesn't have to be possible to enter immediately. It is sufficient if it can take place within a reasonable period. And there is a degree of overlap between the concept of potential competition and that of supply side substitutability for the purposes of market definition. But as the Advocate General explained in the generics opinion, the distinction is that supply side substitution is really about the possibility of immediate entry to impose a competitive constraint when you're defining the market, whereas potential competition can exist as a constraint even if it fails to materialize in the short term. The final consideration, and this is one I think that is worth emphasizing, is that the court in both generics and Lundbeck emphasized that uncertainty is inherent to the concept of potential competition. And in Lundbeck, the court explained this by reference to the distinction between actual and potential competition. Both of these concepts are recognized and protected in EU law, but they are legally distinct, and therefore it doesn't make sense to have exactly the same legal test for both. If you were going to require absolute certainty about outcomes, that would apply the test for actual competition to the legally distinct concept of potential competition. So you have to be a little bit more comfortable with uncertainty when it comes to potential competition. Related to this is the fact that potential competition is judged by reference to the circumstances and state of knowledge at the time the allegedly anti-competitive behavior occurred. This means that later developments that mean potential competition is unlikely to crystallize don't negate a finding of potential competition. For instance, in Lundbeck, the originator company won some of its patent cases, but that didn't change the fact that there was considered to be potential competition with the generic manufacturers when the original agreements were signed. And I think the final point I would make is that this suggests that potential competition is a more flexible concept and perhaps a more useful one as contemporary competition enforcement moves away with the preoccupation with type 1 errors, tries to embrace a more dynamic perspective. The flexibility that you see within the potential competition concept as it develops potentially will be a nice conduit by which we can bring some, I suppose, broader, more nuanced considerations into competition assessment.